Okay, I think we can go ahead and get started. Thanks for everyone tuning in. My name's August Schwartz and I work for What's Up Media. Today we're going to be joined by tax attorneys Rebecca Sheppard and Peter Haukebo from Cross Law. They're going to be discussing how to maximize your PPP loan. Please feel free to post any questions in the Q&A box below at the bottom of your screen, and we'll do our best to answer them at the end of the presentation. Again, if you liked what you saw here today, please join us next Tuesday at the same time on the 9th at 11 a.m. The topic we'll be discussing is how to handle business interruptions, cash flow, leases, insurance, employees, and more. Go ahead and take it away, Rebecca.
Thanks so much, August. We appreciate being here, being able to help kind of explain all of this PPP stuff. But just so everyone knows what Peter and I do, typically when we're not having a global pandemic, is we're tax controversy attorneys. So we handle businesses who have payroll tax liabilities, wondering whether somebody should be an employee or an independent contractor, how to get into payment plans and get into collection alternatives with the IRS and other tax jurisdictions like Comptroller of Maryland, Department of Labor, licensing, regulation, Virginia, DC, all that kind of stuff. So right now we're dealing with the PPP issue, so we'll kind of hop right into it because I know our time is limited. And August will be sending out these slides if anyone's interested in them, afterwards. So the payroll protection plan and loan forgiveness. So it took about 6 weeks, but the SBA actually issued loan forgiveness guidance. We've been waiting for it, so pretty exciting. There are still funds available if people have not applied yet, or if they're having problems applying. If your bank is saying you have to wait or something like that, reach out to Peter and I. We have some contacts that we might be able to get you your loan. And if you're wondering what you can apply for, the maximum loan amount of the PPP for each borrower will be the lesser of 10 million. I think most of the $10 million ones have already gone through, but there's a lot of smaller businesses still trying to get loan amounts. I had a client get funds 2 days ago. So it's still very much in the works. So $10 million, or the average total monthly payments for payroll costs incurred during the 1-year period prior to the loan date, multiplied by 2.5, plus the outstanding amounts of an emergency injury disaster loan, EIDL, obtained on or after January 31st, 2020, which will be refinanced under the loan. Payment deferral for the first 6 months, including interest, principal, and fees. Interest will continue to accrue during that deferral, and the interest rate on loans under the PPP is 1%. So some of this is actually pending in Congress right now and is subject to change, in which case Peter and I will probably have to do another webinar to explain it all, but just so you know, right now it's 2 years with a 6-month deferral. The House is asking for 5 years, and deferral until forgiveness application is ruled upon, is decided. So that could be a huge difference. Payroll costs mean the sum of payments of any compensation with respect to employees, that's a salary, wage, commission, or similar compensation, payment of cash tip or equivalent, payment for vacation, parental, family, medical, or sick leave, allowance for dismissal or separation, payment required for the provisions of group healthcare benefits, including insurance premiums, payments of any retirement benefits, or payment of state or local tax assessed on the compensation of employees, and the sum of payments of any compensation to or income of a sole proprietor or independent contractor that is a wage, commission, income, net earnings from self-employment that's not more than $100,000 in a year, so prorated for the covered period. The compensation of an individual employee in excess of an annual salary of $100,000 as prorated for the covered period. No credit received for the employer portion of FICA. So these are payroll costs that aren't included. So anything over $100,000, payroll costs. Originally, the CARES Act had actually said employee portion as well, but that's been changed. So any compensation of an employee whose principal place of residence is outside the United States, and qualified sick leave wages of which you already received a credit under the FFCRA. Basically, you can't double dip. Limitations on loans. So PPP provisions that can reduce or eliminate the amount of forgiveness, spending less than 75% of the PPP loan on payroll costs, reducing full-time equivalent employee, FTE, and reducing employee compensation by more than 25% during the covered period. Again, there is some legislation that has gone through the House, and we're waiting to see what the Senate does. That's going to change that. If it's approved, we'll change that. Where they're saying it's going to be 60% of the PPP must be used on payroll costs. So right now, we're not reviewing that 75% as a cliff. We're looking at it as a way for it to tamp down the amount of the loan that's forgivable. That 60% number looks like it will be a cliff, in which case you must use 60% of the loan on payroll costs to get any of it forgiven. Again, payroll costs do not include compensation exceeding $100,000, sick leave that's already been paid, and payments to an independent contractor. There was a lot of hullabaloo about independent contractors in the beginning. Now I think it's pretty clear, if you're an independent contractor, you should be applying for your own PPP right now. This is the time. And if you've got questions on it, Peter and I can answer offline. On May 15th, now I can't even say this is new SBA guidance because they also issued something on May 22nd, but here we are. On May 15th, the SBA issued release number 20-41 saying that there's a new application for forgiveness and corresponding instructions. So here's a screenshot of the application showing you what you would need to do to apply. Now this is SBA's form. The bank could use a different form. They could use the same form. You're not really sure yet. Key highlights. So covered rent obligations. Borrowers are now assured that covered rent obligations include business rent or lease payments required under lease agreements for either real or personal property, which were effective before February 15th. So that's huge. If you have some company cars, if you have company copiers, Xerox, and that kind of thing, you can use those in your 25% number. And again, if Congress passes this new legislation, that would go to 40%. The covered period right now is 8 weeks. Like I said, it could be extended through the end of the year. It's specifically defined as 56 days. According to the instructions, the first day of the covered period must be the same as the disbursement date. However, if you have a more frequent payroll schedule, if you have biweekly pay or more frequent than biweekly, so if you're bi-monthly, you're not able to use this. But if you have a biweekly pay or more frequent, you're able to actually move your payroll covered period to the first day of the pay period once you receive the loan. So the period begins on the first day of the first pay period following the PPP loan disbursement date. So sometimes this is going to make sense. In other cases, it may make more sense to kind of keep the original date when you receive the funds. You're going to have to look at that for your company and make that decision. Here's an example. If the borrower received its PPP proceeds on Monday, April 20th, the first day of its first pay period following is Sunday, April 26th. Then the last day of the alternative payroll period is going to be Saturday, June 20th. So 56 days from that Sunday, April 26th date. So payroll costs, which are incurred but have not been paid during the borrower's last pay period, are eligible for forgiveness if the payroll costs were paid on or before the next regular payroll date. So because of this rule, that alternative payroll doesn't necessarily help you as far as like allowing more funds to be forgivable. It just kind of gives you an ease of accounting. So you don't have to do a special payroll or something like that, which in the beginning, Peter and I were advising people that might be beneficial to them. And this way, it actually seems like the SBA is working with businesses to make this easier, to make sure that more things are covered. So again, new guidance issued on May 22nd limits owner employees to either 850 seconds of 2019 compensation or $15,385, whichever is lower. This is a big deal because there was guidance issued on April 14th that singled out sole proprietors, stating that their compensation was going to be limited to 850 seconds of 2019 compensation or $15,385, whichever was lower. And at the time, we thought this was kind of a boon for the S-Corp owners because they weren't restricted in this fashion. So it was possible for them to increase their wages. There's a lot of times where a business owner still has distribution, still makes money, but at the end of the day, due to depreciation and other things, it may not look like the business made that much money, in which case that would be, that was harming the sole proprietor. here, everyone's kind of in the same boat, 850 seconds of 2019 compensation or 15,385, whichever is lower. So there aren't any, there's no creative accounting that you can do with this. This is just what you're going to be able to forgive if you're an owner. So employer contributions. During the covered period, contributions by employers to employee health insurance, including employer contributions to a self-insured, employer-sponsored group health plan, as well as to employee retirement plans are forgivable. Any pre-tax or after-tax contributions are not forgivable. So note that based on the guidance thus far, only health insurance is forgivable. Other types such as disability insurance are not. This retirement piece is big. There are no qualifications on it. So for people who want to spend all of the money and are able to within their employer plan, they're able to make, additional retirement contributions. It's not based on what 2019 figures were. So like I just said, new guidance issued on May 22nd, retirement contributions for all employees are not qualified in any way. Another piece of this May 22nd guidance, which I don't know if you guys have a calendar in front of you, but that was the Friday night of Memorial Day weekend. So SBA really knows how to make holiday weekends fun for me and Peter and other people who are following this stuff. Hazard or bonus pay for employees earning less than $100,000 annually is permitted. So some conservative CPAs in the beginning were telling people not to bonus out their employees, increasing their compensation up to $15,385. SBA says you can do it. So if that's something that you want to do, something to look into. Again, Congress is considering stretching out this covered period. So I wouldn't suggest doing this now until they've kind of made a decision on that, unless you're right at the end of your period, in which case, if you want to give me or Peter a call, we're happy to answer, quick question, kind of strategically going through what your best options are. There is some tax treatment that we'll get into in a little bit. So business utility payments are defined as business payments for a service for the distribution of electricity, gas, water, transportation, telephone, internet access, for which service began before February 15th. New guidance issued on May 22nd allows utility costs that are incurred during the covered period and paid after the covered period has ended. So if your covered period ends, if your covered period ends on June 15th and your electric bill you get on June 30th, you can prorate that bill and take that portion of your expense on your forgiveness application. A transportation utility has been interpreted to mean fuel costs for business vehicles. So while that's nice and all, not a lot of people are driving a whole lot right now. So it may not be as helpful as it would have been under normal circumstances. But if you are driving, then this is something that look into. Make sure you're keeping track of your gas payments, and it's something that you can count in that 25. And if Congress passes the rules, it'd be the 40% forgiveness. And this is where Peter's gonna pick up.
Sure. So again, just want to reiterate that there are still PPP funds out there. So, if you haven't applied yet, you definitely want to apply now. So Rebecca's been talking about the various expenses that, things that you can spend on to achieve or to use your loan. What I'm going to talk about a little bit is how to get full forgiveness. And so there are a couple of ways to keep in mind. And, the first is, well, let me reset a little bit. There are a couple of hazards that you got to watch out for that can throttle back your loan forgiveness amount. And that is in situations where you've reduced your full-time equivalent employees or you have reduced wages more than a set amount. Some of this stuff sounds like it may be in flux with what Congress is doing, so we'll try to identify those as we go along. The first important thing, and we'll work through how this works, but some important points that has come out in the last couple of weeks. So first is that independent contractors, owner employees, and self-employed individuals, partners can't be included. So if you're the business owner, you're not included either during the reference period or during the covered period or the alternative payroll covered period. So to the extent that you're not bringing back employees and trying to cover yourself, you could be in a situation where you end up with issues related to your FTE count. The next really important point that has come out recently is that the full-time equivalent calculation, there was some back and forth. People were speculating, what is the denominator here to figure out how this was going to work. The denominator is going to be 40 hours. They considered but didn't use a 30-hour comp, which, for some businesses, you've already been tracking it because that's the Affordable Care Act denominator. They didn't do that here. This is just a straight 40. The calculation is figuring out the average number of weekly hours during a reference period and during a covered period and comparing the two. The other big one is that there's a simplified method. So, you may have someone who works 10 hours and 10 divided by 40 would be a 0.25. What they have said is that anybody who is less than full-time, you can just count as 0.5. So that would be, anybody at a 0.25, or maybe you had somebody who worked in 30 hours, that would be at a 0.75. You can use a 0.5 comp for them as well to figure out. The other important point is that even if you have somebody that works 50 hours a week, you don't go above 1. So the maximum amount for any employee is going to be 1. So the other important concepts here, there are reference periods, look back periods to determine how all this stuff works. And so for the wage reduction, I think this may be a little bit out of order, but for the wage reduction, general rule, you're looking at Q1 of 2020. What were the annualized wage for an employee or their average hourly rate for an employee during that Q1, and you're comparing it to your covered period, which right now is defined as 56 days. So there are a couple of exceptions to this. The big one is someone makes a written offer to rehire someone or to eliminate a reduction in hours. So you didn't actually have to terminate them or fully furlough them, but if you reduce their hours and you offer in a written form for them to come back, it needs to be at the same rate and the same hours as was the case before you furloughed them. So the pay period immediately before that, if you offer that rate and the employee rejects your offer to come back, what has come out is that won't affect your FTE or wage reduction comps. What is a major change over the last couple of weeks here is that the employer themselves has 30 days to report this fact to the unemployment agency for the state. So for Maryland, it's the Department of Labor. There are a couple of other exceptions. If you fire someone for cause, if that person voluntarily resigns, or if they request a reduction in hours. The key takeaway here is that you need to document all this stuff. With respect to reporting to the unemployment agency, all the SBA has says is that be on the lookout for more guidance about what you have to do. So even that is still an open question. We don't know exactly how that's going to work, but there are some exceptions to how these reduction in forgiveness is going to work. Go on to the next one. All right, so there's really two ways to make sure that your forgiveness is maximized here. One is by using the safe harbor, and so we'll go through these safe harbor rules. So for full-time equivalent employees, first the employer needs to choose a reference period. And they can choose at their discretion either February 15th of 2019 through April 30th of 2019, or they can choose the first 2 months of 2020, so January 1st through February 29th. If you're a seasonal employee, you can also choose any 12-week period between May 1st and September 15th as a reference period. And excuse me, I'm not talking about the safe harbor at this point. I'm getting mixed up. So this is the general rule for forgiveness. The safe harbor, you're comparing what happens during your 8-week period, and specifically if you eliminate the reduction in FTE by, at this point, June 30th. We think that may change to December 31st. But if you get your FTE count back up, the fact that you reduced employees between February 15th and April 26th won't affect you. Couple of points, it says by no later than, so it doesn't necessarily mean that you have to have this cured on June 30th, or if the law change comes into effect December 31st. But if you do it before then, you should be okay as well. The wage reduction safe harbor is a comparison for the wage between February 15th and April 26th of 2020. And if you increase and reduce the wage reduction to pre-coronavirus levels, to the levels before February 15th to April 26th by June 30th, again, you won't be have your forgiveness reduced. The key here with the wage reduction is you can reduce someone's wages up to 25%, but you can't go beyond 25%. And so any amount above 25% would reduce your forgiveness.
Just a quick point, that's only for people who make under $100,000. So if you make over $100,000, you're free to reduce their wages. You're good to go.
Yeah, it's a good point. So it includes anyone who was a new employee in 2020, and then anyone who during any pay period in 2019 did not receive a pay that annualized would be more than $100,000. Good point. And so Rebecca touched on it earlier, but how to apply, the SBA has come out with this loan forgiveness application. There's a couple of schedules. They have specifically said that the banks can develop their own as long as it's substantially similar. If you've applied, most of the banks have built out their own platforms. But exactly what is going to be required for substantiation and documentation showing your costs, we still don't really know. They have referenced the need for bank statements, showing these expenses. But beyond that, I think we anticipate you needing a Form 941 showing, your payroll costs during the period. But we still don't really know exactly what is going to be needed.
Be on the lookout for a Friday night drop. I think this has been the expectation lately. It just probably this Friday, something will come out about this. They might be waiting to see what happens with this legislation, if it goes through or not. So if it does, it's going to put a lot of this. They're going to have to issue a lot more guidance.
So should we jump into some of these questions?
Just really quick before we get into questions, and like I said, August will send out these slides. So this kind of goes through what the forms you might need, the different kinds of the application and the schedule and all of that. But just quickly, when the CARES Act was enacted, Congress said specifically that these forgivable loans would not be considered a cancellation of debt and therefore wouldn't harm the business. However, since then, guidance has been issued saying that, okay, we won't count it as a cancellation of debt, but the business is not going to be able to take this as an eligible expense either. So
the importance of what Rebecca's saying is canceled debt means income to you. Sorry,
yes. So typically Peter and I talk to tax professionals, so I forget that not everything is for everyone. I should explain better. But yeah, so cancellation of debt is saying that it's income for the business. Now, they're not saying it's income. What they're saying is you don't have to take this as an income, but if you're paying your people, you can't take that as an expense on your income tax return in 2020. So this is going to increase a lot of businesses' income tax returns if you are operating, maybe not at full force during this period of time, but maybe at 80%. It's something that you really want to take into consideration, especially if you're thinking of bonusing people out for the purpose of using this money. You know, think about what the back end of that is going to look like, and either talk to a CPA about it, talk to me or Peter, figure out what makes sense in that regard.
Yeah, I mean, they're concerned about having some sort of a double tax benefit, and they're using analysis for Section 265, but it's basically functionally saying you don't get an expense, you know, related to tax exempt income. And the folks who are pushing back here are saying, look, it's not tax exempt income, it's excluded, which may seem like a difference without a distinction, but in tax law, it is a very important distinction. So definitely seek out a professional if there's no more clear guidance that comes out regarding this.
And CPAs are all up in arms about it. They're planning on challenging it. This is not the intent of the act, et cetera. So something will come of it, but while you're making these decisions on how to spend the money, this needs to be part of the strategy and the calculation, which is why it's important to talk to a professional when you're making these decisions, so that way you understand exactly all decisions you're making and what the consequences are. So are there questions?
Yeah, so I'll go ahead and get through these.
Sure.
We have quite a few, which is great. The first one is, if we have unused funds after the 8-week payroll period, can we retain the funds at the 1% loan payment plan?
Yes.
Yeah.
Sorry.
No, go ahead.
You still have to use PPP money for PPP purposes. So it's not like, oh, well, you didn't use it during the covered period, now you can go build a deck for your business. You still need to use it for payroll costs, rent, things like that.
Yeah, and you know, for those of you who have gone through this process already, you've signed a promissory note that includes language that says, you know, I intend to, you know, spend this on payroll costs and no more than, you know, 25%. Maybe it's going to go up to 40% of non-payroll costs. So you've said you're going to try to do this. So I think it's, you know, problematic for folks who are going out and getting these loans and you know, like Rebecca said, not using it on the intended purpose, but they definitely contemplate that this can be converted to a loan.
Well, and just by the nature of the loan calculation, you're taking payroll costs for 2.5 months, and you're saying you can use them over 8 weeks. So, it's not a perfect calculation. So I think it's absolutely, people are having problems. I mean, it's a good problem to have, I guess, but people are struggling with how to use all of these funds and what's the best.
Right, and that's the you know, you've got a self-employed person who works primarily out of their house. By definition, the way this works is they cannot get full forgiveness if they don't rent, if they don't have utilities. That's going to convert to or remain a loan. It won't be forgiven.
All right. This one says, so copier and equipment leases are allowable if the payments occur in the covered period. I thought it was for property leases only.
So the new guidance that came out May 22nd says real or personal property leases. So vehicles, copiers, all of that stuff is fine as long as the lease was in effect prior to February 15th.
Okay. If we prepaid our 2020 office lease in 2019, will we be able to claim any portion of the payment for the months included in the forgivable loan period?
I don't think you can prepay any payments.
No, but they're talking about prepaying even before this. You definitely can't prepay.
You can't reimburse yourself for a payment. That's not permitted. Now, just to kind of circle back a little bit on the PPP, the loan, if you don't use all of it, for the sole proprietor, it is an opportunity for people if you've had a project that you've wanted to do, books and record keeping is a mess and you're really looking to have that fixed, but you haven't had the funds or the time to do it, now's a really good time to hire a bookkeeper. It can be a family member. There's nothing that says that it can't be. I have people that have hired their spouses to help with these kinds of things. And typically the spouse is already involved in the business. They're just not actually getting paid for their services. So we strongly discourage you from having a spouse just kind of be in name only and getting funds. But if they're doing work for you, it's completely permissible to have them as an employee doing work. That's totally fine. So that's something that people are doing to kind of work through this whole process.
What is the definition of an owner employee? What about 15 shareholder employees of C Corp, each with 6% interest and each also a W-2 employee?
Peter?
Yeah, I mean, so the section of the guidance that came out on May 22nd references owner employees, self-employed, and partners. You know, as I read through it, immediately read owner employee as S Corp owner, but I don't think there's anything in there that would say it couldn't also be read as C Corp. So until additional guidance is out there, I think we have to assume that an owner employee is also a C Corp owner employee.
And additional guidance will come out and there will be more FAQs. I mean, this whole process, it's been like every 2 weeks we get something or every few weeks. So we expect more to come to explain it. We
have, what, 50 FAQs now that have come out. We have 7, 8, 9 interim final rules. There's going to be more. We have the application and instructions. It's all coming out piecemeal. So there'll be more that'll come out on all of it.
Especially if this legislation passes, in which case it's going to kind of turn everything on its head. Because what if you got your money April 8th and your period's about to end in 4 days? Like, what does that mean for you? We'll find out. Next question.
I just lost the last one. Hold on 1 second. For pension plans, when is money considered paid? When sent to the bank account, sent to third-party administrator, or when actually deposited?
So there's not specific guidance with reference to a pension plan, but with respect, I mean, I think we can glean, you know, how they're going to look at this based on the guidance that did come out with respect to wages. So wages are considered paid as soon as you initiate the payment. So I think that they would probably be okay to take a similar track with that. But you know, the one interesting thing that did come out with this once the guidance came out, well, actually once the application for forgiveness came out, the text of the CARES Act says paid and incurred. The guidance and the application really flips that on its head and says, you know, if this was either paid or incurred during this covered period. Again, this will be one that, you know, I think will come out and be fleshed out more and more as additional guidance comes out.
A lot of people I know didn't pay rent for April. They're expecting this to come through, or didn't pay rent for May, expecting this to come through. And so it's a pass-through liability. They can pay it in the covered period and it's allowable as long as it doesn't mess up your percentages.
All right. I'm going to skip around here and try to combine some of these, but this one says, I work for a law firm, 3 partners. Did I just see that payroll may not be counted for partners?
No. Guaranteed partners receive income that is subject to self-employment tax, and it is a payroll cost. You have to limit that to $100,000, so $15,385 for each partner.
Okay. Are retirement matches allowed, i.e. for an S Corp owner?
Yeah.
There's nothing about retirement. That was like the craziest takeaway I took from the May 22nd. It was like a footnote 2 or something on page 6, and it said retirement and nothing else. If you're an owner employee, it doesn't say you can't do as much as you want to. Just remember that you're going to be paying taxes on it on the back end.
And just keep in mind, it's not the salary deferral amount that an employee may choosing a 401k or something like that. It's an
Fair contribution.
payment of the company, of the employer. So making a contribution to a SEP, some sort of safe harbor contribution related to a 401k plan, but it's not the salary deferral amount that's going to be forgivable.
Okay. This one says, how will the FTE work for sole owner S Corp if owner is not included in FTE? And also for FTE 40-hour amount, how does this apply when we use a 37.5-hour work week?
Yeah, I mean, the guidance was clear that it's 40 hours. The denominator is 40 hours. So if you're working 37.5, you divide that by 40 and that's your quotient.
Or you can just use the alternative method and just have it be 0.5. And then if you want to bump people down a little bit, 37.5 to 32, you're still fine. You're still, like, if you need to reduce people's hours, you're still within the rules.
Yeah, I think it's pretty forgiving. How does the FTE work for sole owner? They're just not included in the reference period and they're not included in the covered period. So, I mean, the big one for me in this example is thinking about, restaurants who, have furloughed their employees and, they're just running the kitchen and you've got one front of the house person, but maybe it's the owner doing it. I mean, that's where you may have some issues in situations like that. But how does it work functionally is they're just not included in the reference period and they're not included in the covered period.
Can you repeat the limitation on S Corp owner's pay? Did you say we could not include their wages in the forgiveness calculations?
No, so it's however you paid yourself in 2019. So if you're an S Corp owner and you had a W-2 and you paid yourself $100,000, then you're limited to $15,385 and you're fine. The problem you have as an S Corp owner is there are times where people don't take big salaries and they take a lot of their income through a K-1. And that K-1 income isn't includable. So if you're an S Corp owner, it's 8/52 of your W-2. If you don't have a W-2 and you're an S Corp owner, you're not able to get compensated through this program.
So this may be a really good learning lesson for
people to take a reasonable salary. Yeah.
There's really two points here where you may have really gotten hit through this PPP program. One is if you haven't been paying yourself a reasonable salary, and if you have questions about that, definitely reach out to Rebecca or myself. The other is if you've got folks that you're paying as independent contractors, you weren't able to borrow based on payments to them. So it may be the right time to convert some of those folks over to employees who really should be. So we'd be happy to talk through that and the considerations there, because you weren't able to borrow or you shouldn't have borrowed based on those payments as well.
Okay.
Yeah. So just for people who don't know, if you're a sole proprietor, all of your income flows through in your Schedule C. It doesn't matter. So let me just kind of back up a little bit. If you're a limited liability company and you're a sole person, say I have my own company, I'm an LLC, Rebecca Sheppard LLC. I can choose to be taxed under a Schedule C. It's a default, so like proprietorship, and it goes onto your Schedule C, comes through my personal income. Everything flows through on my 1040. Or I can choose to be taxed as an S corporation, in which case I'm required by the IRS to take a reasonable salary, and then my other income that I receive, I can take as a profit. So my salary is a W-2, I pay taxes throughout the year, and then if I've got another $50,000 in profit, I take that as a K-1 and I'm not paying payroll taxes on that. So a lot of people will play with that number in order to reduce their payroll taxes. Payroll taxes when you're a sole proprietor is 15%. So if you can reduce from $100,000 to $50,000, a lot of people do that. This is the one time that didn't work out because you're not able to take your full salary. You're not able to take your full income as an S Corp owner, if that made sense.
Okay, an employer reduced wages 2 weeks prior to furlough by 20%, subsequently furloughs employees. When the employer brings back employees, at what wage do they need to pay? And if they do not pay 100%, is the employee eligible to collect unemployment?
So there's two possible reference periods. If you're relying on the safe harbor, then the wage that you need to bring them back at is the wage that they were paid between February 15th and April 26th. If they weren't paid a wage at that point, then you're not using safe harbor, and then you're bringing them back at a wage that they were being paid during quarter one, as much data as you have before they were furloughed. That's the reference period for the general wage reduction rule. Let's see, if they do not pay 100%, is the employee still eligible to collect unemployment? Unemployment is not an area that I've been tracking. Rebecca, do you?
I've looked at it briefly, and I don't believe if you're making, I think you kind of have to take a dollar for dollar reduction in what you're receiving. And so if you earn $1,000 and you're getting $1,000 from unemployment, you won't qualify, but otherwise it's like a sliding scale. Definitely double check that. And keep it in mind that I don't believe you can't double dip. And unemployment benefits aren't designed to fully make you whole. They're supposed to be enough to get you, basic necessities. So if you typically make $100,000 a year and you get brought back on at 50, you're not going to be able to kind of make up that gap. That makes sense.
Okay. We own several businesses and don't take a salary from all of them. We did get a PPP loan for all of them. For the owner's salary, if we didn't take a salary in 2019, can we take one now and be part of the forgiveness?
Peter, do you want to talk about the?
Well, yeah, I mean, the really big take home here is that even across all businesses, you are capped at that 15,385. So that's one major consideration. But if you didn't take a salary in 2019, you're going to run into that same issue that Rebecca was talking about previously, that, if these are structured as S corps, or even C or partner pay, it's based on 2019. I'm just rereading the question. I mean, salary replacement works a little bit different. Owner compensation replacement looks a little bit different in a Schedule C situation, a sole proprietor. So you may still get something, but you're otherwise capped across all businesses. That's the main take home.
Total is 15,385.
When it says owners are not included in the PPP, does that include the S Corp owners who are salaried W-2 wages and part of the payroll? They need to be deducted from the allowed payroll cost.
When we say owners aren't included, we mean in the FTE calculation only.
Yep.
You're still able to take your salary. You're still able to get your health insurance. You're still able to contribute for your retirement plan. All of that stuff still counts. It's just you don't get to count the owner as one on your FTE scale.
All right, we got about 5 minutes left, so I'm going to jump around here. What about management fees paid to an LLC partner? Are they eligible to subject to the 100,000 limitation?
I don't know. Management fee is not a term I've seen used in any of this. I would say that would be not an allowed cost, either on the payroll side or on the non-payroll side. If you want to contact us offline, we can talk.
We can go through the contract and see what that means, but yeah.
Yeah.
I agree.
Okay, we typically have employees travel together in one vehicle for job completion. During this time, COVID reasons, we have asked employees to drive separately using their own vehicles and have paid them a travel allocation. Can this be used for the loan?
So you're reimbursing a cost.
I don't like it. This may be one that we could talk through offline, but I think based on the definition of utilities, you know, I don't think it fits in there. It's not a reimbursement. You know, maybe if you're, you know,
I would give them a credit card to pay their gas on and then use it that way.
Mhm.
And then I think you're fine. I think when you're reimbursing, you get it's an extenuating line. If they had like a mileage log, possibly, I think you can certainly make an argument for it. But it's going to be a lot cleaner for you if you just get them a credit card and have them charge at the Citgo station, and then you can show your vehicle costs.
Okay. If you furlough someone in mid-May at the June 30 date, do you count the full quarter or just a month for time laid off?
If you bring them back, then you're going to be under the safe harbor and you shouldn't be penalized.
That's the June 30 date, is they want you to restore any reductions by that date, and then you should be fine.
And there's nothing that says, and this is terrible, but there's nothing that says you can't bring somebody back June 28th. And if your period ends July 5th, get rid of them on July 5th. Get rid of this the wrong word, but furlough them or lay them off on July 5th. There's nothing that says you have to keep them on for a certain amount of time or the equivalent of a covered period or anything like that. It just says by June 30th, and that's all. And again, if Congress passes this legislation, then we're looking at December 31st as your date that you have to rehire by.
Okay. What documentation is needed for an employee who left voluntarily after receipt of PPP loan?
I would think a letter of resignation.
Yeah, we don't know exactly what they want, but it's clear they want documentation. Get a letter of resignation, get an email where they confirm something, you know, have it.
And if not, I mean, if they refuse to do it, they've just like fallen off the radar, you could certainly contact them and say, you know, per our conversation, you know, make sure that you have something memorialized in writing. Per our conversation on May 15th, you resigned, you gave 0 notice, or you gave 2 weeks notice, and this is your last date. And this is, you know, what you would typically do under these circumstances to show somebody resigned versus, you know, being terminated.
Okay. I have a seasonal business and apply for the PPP loan using a portion of the year. When the application was reviewed by SBA, I had to revise the application to agree with the 940 that was submitted. I can't bring most of our employees back until the business picks up. What do you suggest?
Back to the bank and try to modify your loan, because that's incorrect. Guidance has since been issued and they should be able to let you do it. And if they're not, that's something, meet Peter, your CPA, someone should be able to have a conversation with them to explain why that's incorrect. There's specific guidance out there for seasonal employees, seasonal employers, and how those calculations should work.
All right, this is going to be the last question. If the safe harbor date is changed to 12/31, then we would not apply for forgiveness until then if we were concerned about meeting the FTE for a company with fluctuating FTE based on construction projects.
So it's a big if still, because we've only passed one, you know, the one legislative body. But I would say you have to look at your whole picture and see what makes sense for you. Part of this legislation is saying you can opt in for an 8-week period, or you can opt out and do the December 31st period. If you're like 5 days out from finishing your loan, it may not make sense for you to keep this liability on the books and worrying about it for another, you know, however many months. And it may make sense for you to do the 8-week. If you're worried about the FTE portion of it and you're not able to bring people back, I would just look at, what does that mean? If you offer them to come back, are they not going to come back? You know, Peter often talks about this, the point of this plan is to pay people whether they're working or not. So I know that's hard for a lot of people to pay people to not work. And if you think that it's just something you kind of need to think about all the way through, and whether or not it makes sense to bring them back now or to wait. You know, this legislation isn't passed yet and we don't know if it will. So it's hard to kind of bank on that.
Okay. How can everyone get in touch with you guys?
I think, let me see if I can find our contact info. I'm sure there's an easier way to do this.
On our backgrounds, right?
It's on our backgrounds, but it's all small.
Got it.
And, ooh, And here we are. Hello. So those are our emails. We're happy to answer any questions offline. I know a lot of this stuff is really specific to your business, like, so it's not always that we can catch every point that's here. So we're happy to answer anything offline, or if you have any other questions regarding whether somebody's an independent contractor or, you know, tax liabilities, things like that, we're happy to discuss that as well.
Great.
Thanks so much for having us. We appreciate it.
Thank you.
Absolutely. Thank you for making a convoluted thing.
Hopefully it's a little easier to understand.
Yeah, I mean, it's a lot of stuff, but we had a ton of questions. So people, please contact them with your specific questions. The slides and the recording will be available later today. And please join us again next week for our second topic, which is how to handle business interruptions, cash flow, leases, insurance, employees, and more. We will have different presenters from Frost Law, but it's definitely going to be some good information. So tune in.
All right. Thanks so much.
August.
Thanks, guys.